Often it's quite confusing for people because it's a vastly different system that they're in at that point. It's the state or the DA's office versus the person, and even though if it's a domestic assault situation, they think the alleged victim has brought the case against them, that's not actually true. It's the state, started by a police department usually, that brings an action against you, and often even an uncooperative person who doesn't want you charged with a crime can be forced to participate in the system. And so the first issue to get really straight is the state is against the person who's charged with a crime. The next thing is it's often the first time the person realizes they're going to be charged is when they're arrested. And Maine is a pretty good state with regard to bail. If the person's history isn't too awfully bad and they've appeared in court for any other things that they've had, Maine often grants bail. It's a very good state for bail. Sometimes it's with a cash component, often not. But there are often conditions with regard to especially domestic kind of cases of no contact with the alleged victim, sometimes with the children. Sometimes it's not to possess firearms or other dangerous weapons. And you want to mind those bail conditions because you can get arrested and charged with a separate crime for violating conditions of release. If you're not arrested, often you're summoned, and that's just an order to appear at the court, like a ticket almost. And in the bail, you get a bail sheet when you get bailed, if that's what happened, if you got arrested. And the conditions are on the bail sheet, as is the court date that you must appear. So either on the summons or on the bail sheet, there's a court date, and you have to go to the court on that date. That's your arraignment. If it's a felony level offense, that arraignment date, you still have to go to that, but the actual arraignment might be delayed pending indictment. At that first initial arraignment hearing, issues of bail can be addressed. So for example, if the alleged victim wants to have contact with you or wants to allow children to have contact, and so you have to make those arrangements, that is an opportunity to address those issues there. You can actually address those earlier too if they're necessary and an agreement can be reached. After that, most counties in the state of Maine are part of the Uniform Criminal Docketing System, which is a single court for criminal cases, both misdemeanor and felony level cases. You are entitled to a jury trial. Traditionally, you had to request a jury trial if you wanted one for a misdemeanor, but that has largely been dispensed with in counties that have a uniform criminal docketing system. And you are automatically in line for a jury trial. That happens after your arraignment. At your arraignment, your attorney or you usually get the police reports of the incident. They're very important because that's the state or prosecutor's office perspective on the evidence supporting a conviction. Sometimes it's not complete, or there's other information that a person knows is out there that you can seek. You can get it from the prosecutor's office if they have it, or you can conduct or have a private investigator conduct an investigation for those things that the district attorney's office might not have access to. And there are, under the Uniform Criminal Docketing System, a motions hearing date, and that's very important in a criminal context especially, because that's often where constitutional rights and whether or not they've been violated are litigated, and they can have a profound impact on whether a conviction occurs or not. For example, if a statement was taken from a defendant when they were in a situation where they were under arrest and they weren't given the appropriate warnings, that is deemed to be custodial interrogation, and without the proper warnings, it's not admissible against the person. Sometimes the alleged victim is also an aggressor, and the issue comes up, was the defendant defending themselves as opposed to committing a crime? And so sometimes an alleged victim admits that's what was going on and is helpful that way. Sometimes you interview them and they lay out that that's what happened. So, and sometimes those people have their own rights that need to be protected, not by the defendant's lawyer, but just they need to be informed that they may not be required to testify, for example, because they are implicated in crimes themselves. And the jury trial, although it's frightening to most people, is a tremendous protection for folks, ordinary citizens, that we have, and it's relatively unique in the world. And, you know, as much as any other way that exists to sort of arrive at the truth, it works. It really does. And it's very much a protection for the accused that's constitutionally entrenched. And in Maine and in most other jurisdictions, the jury has to be unanimous as to every element of the crime. And if they're not unanimous beyond a reasonable doubt that every element of the crime has been committed, or that the defense, for example, has been disproved beyond a reasonable doubt, the jury has to acquit. And if they can't reach a unanimous verdict of guilty or not guilty, that's considered a hung jury, essentially, and the person can be retried, but unless it's quite a serious charge, that usually doesn't happen. The state has limited resources, and they just often don't do that. And it's, I think, very protective of the presumption of innocence to have a jury trial. And the way I like to describe it to people is, you know, the jury it's like their first day on the job. They take it very seriously. They listen to the instructions of the judge to only convict if it's beyond a reasonable doubt, that they have to weigh the evidence. They are mindful that they have to be unanimous. And so they take it quite seriously, and it turns out it's quite a protection for people that, you know, have a defense, are, you know, not guilty. The situation is somewhat ambiguous, and a defense, you know, is possible. It really, really works. And so I realize people are very afraid of it. And the whole idea, you know, terrifies some people. It's quite distasteful for other people. But it's a very good system for the defendants in determining whether or not they're guilty.